Welcome, everybody. My name is Greg Peterson, and I am the act before the real show. And my role is I am one of the co-founders of the Robert H. Jackson Center, located in Jamestown, New York. And you just entered the Robert H. Jackson Federal Courthouse. Now, sometimes there are names on buildings, and you probably either are interested in saying, who was that person? Or maybe a name on a building, you just simply say, I don't care. Or it's a name on a building that you see in the news or listen to on the radio, that certain activities occur in the Robert H. Jackson Federal Courthouse. So curiosity, hopefully some of you have, and I'm here to talk about, is who was the guy? Who was Robert H. Jackson, who was a product of Western New York, and he became the answer to a Jeopardy question recently, named the only person in the history of the United States to be Solicitor General, to be Attorney General, and to be a Justice of the United States Supreme Court. Only person. And who was Robert H. Jackson? Who was the first and only chief American prosecutor at the Nuremberg trial, which tried the Nazis, surviving Nazis at the end of World War II, in the first international criminal tribunal ever. And that was a question, and the answer is Robert H. Jackson. And what is the question you now hear, if you're listening to the radio very closely, is should Vladimir Putin and his generals ever be brought to justice? And if there was a tribunal for the crimes that have been allegedly occurring, and I think we can actually say been occurring, because we see it every day on social media and the television and video coverage, is what would be the context. And it would be the Nuremberg trial. And who was the Nuremberg trial? The architect of that was Robert H. Jackson. So Robert H. Jackson is the name on the courthouse. He's also the person behind much of what has happened, which were very, very important in the history of the Supreme Court, and is the name behind the tribunal, which in fact is the one that may be used as a template upon which Vladimir Putin would be tried. Right here, Western New York. A little bit more background regarding him. This is sort of the Reader's Digest. He was born in 1892, and by the way, I think everybody got a book, hopefully, of Robert H. Jackson. It gives you a nice overall review of him. But he's born in 1892, just over the border in Pennsylvania called Spring Creek Township. And there he stayed until age 5, went to a little place in New York State called Frewsburg, New York. For the Buffalo Bills fans, that's the home of Shane Conlon, way back when. And there he graduated from high school, valedictorian. We don't talk about the fact there was only a class of 7, but hey, when you're the valedictorian, you're a valedictorian. And he was a valedictorian, and then he spent 1 year at Jamestown High School, of which I was a graduate. And he never went to college. No college. Never graduated from law school, only attended 1 year of that. And he got a certificate. Read for the law. And at the earliest age, possibly age 21, passed the bar and became a lawyer. He practiced law in Western New York, including Buffalo. His offices were in the Ellicott building. Just right here, literally his path from his apartment, as would have it, to the building, walked right through this place here, where we are today. And as a result, Jackson, until 1934, practiced private law, just like many lawyers you'll be seeing today. And in 1934, he was asked by President Franklin D. Roosevelt to see if he would leave practice for a year or two to go to Washington and become the assistant attorney general in the Department of Justice dealing with taxation issues. He actually sued Andrew Mellon, so if you ever see the Mellon Bank or the Mellon Library or the Mellon anything down in Pittsburgh, that's the guy. He sued him for fraud, and he won. And then he became, in very meteoric fashion, the assistant attorney general. He became a solicitor general, attorney general. He was intimately involved when you study your history about the Lend-Lease program during World War II. He's the guy that wrote the opinion, which permitted President Roosevelt to lend-lease naval ships in exchange, and that actually permitted Winston Churchill to, in fact, have some successes which would preceded our involvement in World War II. He was involved in 1941. He became a justice of the Supreme Court. Now, this is a justice of the Supreme Court, a guy who never went to college, never graduated from law school, from Western New York, the first guy ever from Western New York to become a justice of the United States Supreme Court. Amazing. And he was involved in some of the really seminal cases, some of which you will have read. For example, West Virginia versus Barnett is probably his most famous case. It's a flag salute case. You might read that in American history. It's his decision. Fred Korematsu, who's a Japanese American internee during World War II, was put in a internment camp, and you'll read about that too in your history. He wrote a very important dissenting opinion, which became ultimately the law. Youngstown steel seizure, so when every president who signs an executive order and declares it to be law, and the Congress says you can't have it because you've exceeded your constitutional abilities, because the president can't just simply sign things into law unless it fits a certain guidelines. Those guidelines were created by Robert H. Jackson, your guy. And the most famous case of all, Brown versus Board of Education. He was intimately involved and on the court during that time period to get unanimity. He was instrumental in getting all the justices to agree to, in fact, that unanimous decision in Brown versus Board of Education, which I assume you all are aware. So that's your guy here. Pretty amazing. And again, on top of the fact was the fact of the Nuremberg trial, 1945-46, he was the chief prosecutor. He was the architect for the creation of the court to get all the allies to agree that there would be a tribunal to try people for crimes of aggression, crimes of peace, crimes against all those items that you hear about with Vladimir Putin. It's Jackson. So while you're sitting in this courthouse today, or you're looking at the book, do not read the book while we're doing the program today, because this is an amazing program you're going to see today with United States District Court Judge Richard Gergel. It's incredible. But know full well you're sitting in a courthouse known as the Robert H. Jackson Federal Courthouse, which has that kind of legacy and an answer to a Jeopardy question, and in fact, one which has a relevancy today. He died in 1954, by the way. But all the justices, just an aside how much they revered him, all the justices of the United States Supreme Court got on a train and for the first and only time left Washington en masse to attend a funeral in Jamestown, New York. Quite remarkable. So I am here to just give you a little background of Robert H. Jackson, so hopefully you walk away with a nugget or two. You might listen to Jeopardy. You might go back and check out some of those questions, because know full well you'll know the answer before your neighbors who haven't listened to this regarding Robert H. Jackson. So in about 5 minutes, the court will convene, and you'll have an opportunity to have an extraordinary program today. With that, I thank you very much for your attention.
All rise. The United States District Court for the Western District of New York is now in session. The Honorable Jeremiah McCarthy presiding.
Good morning, ladies and gentlemen. Please be seated. I'm Jerry McCarthy. I'm a United States Magistrate Judge. My colleague Mike Bowman is another United States Magistrate Judge. This is not our courtroom. We don't have marble in our courtroom, but we get by. I've often been accused, once I get behind a microphone, of never shutting up, but I'm going to make an exception today because we have a truly spellbinding speaker with a spellbinding topic. So I'm going to make a few introductions, and then I'm going to turn it over to my good friend Mike Hurley. Mike, let me first of all, excuse me, recognize some of our dignitaries in attendance today. Honorable E. Jeanette Ogden, Supreme Court Justice, who has participated quite often in our programs. Honorable Jahar Pridgeon, Chief Judge of Buffalo City Court. Thank you for being here. Honorable Barbara Johnson-Lee of Buffalo City Court. All three of these judges have frequently participated in the James Otis Lecture. Ann Noble, Executive Director of the Bar Association of Erie County. Rob Mercado of Council Press, who is one of our sponsors, and we thank you, Rob, for everything that you do. In the back row, the guest of honor, Judge Gergel, and you'll hear much more from him in a moment. To his left is Mike Hurley. Now, Mike will not sing his own praises, but I will. Mike has done just fantastic work on behalf of ABOTA, the American Board of Trial Advocates, in presenting these James Otis lectures every year. And you have no idea how much work goes into the program, but I do. And for that, Michael, we thank you. To Mike's left is my former partner, Greg Peterson, who's, I miss practicing law with you, Greg. You're the only one of my partners I miss. To Greg's left is Tina Downey, you're the Development Director of the Robert H. Jackson Center. Welcome. And to her left is Tabitha Salonen, a third-year law student, who's a law clerk at Mike's firm, Horowitz Fine, and I understand that you will be practicing there full-time next year. It's a sweatshop, I just wanted to And with that, where is Belinda? Oh, she's over here. Belinda Gergen, who is Judge Gergen's life partner, wife, and a PhD in history, is that right? And I know that she had a tremendous role to play in the story that you're going to hear today in the book that he has written. And with that, I'm going to turn things over to Mike Hurley. Oh, before I do that, I wanted to recognize the faculty. Molly Green from the Buffalo Seminary. Where are you? There you are. Okay. Mary Manley from Hutch Tech, welcome. Jessica Swick from the Buffalo Academy of the Performing Arts, welcome. And Eric Muhammad from the Emerson School of Hospitality. Welcome to you teachers and all of you students. Michael.
Thank you, Your Honor. May it please the court. I'm very happy to see all of you today. I think I saw all of you earlier in the last 2 weeks. Welcome to the Robert H. Jackson Courthouse. I describe this courtroom that sometimes is a cathedral or a church. How many of the students agree with me now that you've been here? That's what I thought. This is a marvelous place, and we are pleased to be hosted by the federal court for 8 years, and I welcome all of you. The American Board of Trial Advocates, as I told you in our presentation, was formed in 1958. At that time, the attorneys in California believed that the jury trial system was under attack, the civil jury trial system, and they formed an organization to preserve it. So far, we've been reasonably successful, but the jury trial remains under attack today. It is always going to be a fight. There will always be entities and individuals who want to short-circuit the process. So why do we do it? We do it because we believe that civil juries are the bedrock of everything else that we do in the civil practice of law. Civil juries are the ones who are the grounding force for verdicts and compensation of individuals who are injured, or telling injured individuals that they're not entitled to compensation. It works both ways. And that is why the American Board of Trial Advocates is populated by both attorneys who represent civil plaintiffs and those who represent civil defendants. We hope that this is an informative program for you. As I explained to you at the pre-lectures, the growth of mission for the American Board has led us to preserving all the rights that are, seeking to preserve all the rights that are afforded citizens under the Constitution, and also to preserve the independence of judges who at times must make unpopular rulings. And when they do that, judges cannot defend themselves. Others must do it for them. They're not allowed to. So we do that as well. Genevieve, can you put up the next slide?
Yes.
So today is unusual in two respects. First of all, our host, Judge Scretany, our host for the last 7 years, Judge Scretany, is not available. And I thank Judge McCarthy for stepping in. He graciously did so with but a brief phone call. Also today is bittersweet. For the first 7 years, there was United States Magistrate Judge Hugh Scott who participated in this program. You have a portion of his biography that was posted on the Western District website when he passed. I will warn you now, it's not easy for me to get through this. Judge Scott was a friend. I'll go back to happier time when I first met him in the Buffalo City Court. That was a significant number of years ago. I tried matters in front of him there, and I tried matters in front of him in the old courthouse and in this courthouse. And I didn't always win. But I always knew that Judge Scott understood our position, considered our position, and made his decision. He was a judge that understood that justice applied to all. Every litigant in the courtroom was entitled to that justice, and he always did his best to administer justice fairly. He also had a great dedication to individuals who had made some mistakes, served time, and then needed to be re-entered into society. He formed the reentry court in this district, and he managed it until his health no longer permitted him to do so. Beyond that, and beyond being a judge, he was committed to this program. He would get out of his sickbed to be here. He might not stay here because he couldn't stay up that long, but he would be down to talk to you at lunch. On one occasion, we were about halfway through lunch, and he walked up to me and he apologized that he could no longer physically be present. He apologized to me. That's the man he was. Today, and I'm going to try to do this, I might not make it. Judge, you may have to help. Because of what he was a pioneer in this town, pioneer in this district. We dedicate today's program to him. Judge, would you read the dedication?
Whereas Judge Hugh B. Scott was a revolutionary pioneer in the Black community, having served as the first African-American Assistant United States Attorney, Assistant Attorney General, Buffalo City Court Judge, and Magistrate Judge for the Western District of New York. And whereas throughout his exemplary career in public service, Judge Scott consistently demonstrated his commitment to the fair administration of justice for all litigants who appeared before him. And whereas Judge Scott was always committed to the Western New York community and especially dedicated to positively impacting the underserved and those who had strayed from society's path through our judicial system. And whereas Judge Scott was also committed to educating our youth and was an integral part of the James Otis Lecture Series, committing his time and energy, even through his physical setbacks, to not only be an active participant in the program, but also to be an especially strong contributor to the table discussions. And whereas there is no more apt program with which to honor Judge Scott's memory than that of Unexampled Courage, the story of pioneers in the civil rights movement who led the fight for true equality. Now, therefore, the James Otis Lecture Series, together with its partners, sponsors, and supporters, hereby dedicates the 2022 James Otis Lecture, Unexampled Courage, to the memory of Honorable Hugh B. Scott, United States Magistrate Judge.
Thank you, Judge. On a more pleasant note, it is my honor to introduce my good friend Greg Peterson. Greg is a co-founder of the Robert H. Jackson Center, a center which partnered with us day one. Well, day two, actually. Day one, we didn't know what to do. But on day two, Greg showed up, and he showed us the path to this program. What you see is really a result of his ingenuity in designing a program for high school students when Judge Scretany and I were somewhat lost. It is my distinct pleasure to introduce Greg Peterson, co-founder of the Robert H. Jackson Center.
Your Honors, the audience has already listened to me for 10 minutes, so I'm not sure they want to hear much more, so this will be a very brief introduction to an extraordinary individual. The Honorable Richard M. Gergel, United States District Judge, South Carolina District. This is a federal district court judge. He's a native of South Carolina. Judge Richard Gergel traveled a few hours north to obtain a Bachelor of Arts in Juris Doctor from Duke University. Now, if you're North Carolina fans, keep it down. Judge Gergel then returned to Columbia, South Carolina, where he founded his own firm, last known as Gergel, Nichols, and Solomon, before his appointment to the United States District Court by President Barack Obama. He was nominated in December 22nd, 2009, and confirmed on August 5th, 2010. Among the notable cases he had as an attorney, Judge Gergel argued Hall versus Marion School District, in which he successfully reversed the termination of a school teacher by enforcing her First Amendment rights. Teachers, take note. In addition to his legal and judicial career, Judge Gergel is an avid scholar of our constitutional heritage. We had the privilege of interviewing him Sunday at the Robert H. Jackson Center. Just posted it online, and if you want to get an in-depth look at the individual, you'll get a sense of it today. You feel free to watch that. Because his passion for history, it came out in the interview, and I'm sure will come out today, resulted in his research into the role of Judge J. Otis Waring played in advancing the cause of civil rights in our country, and resulted in his authorship of Unexampled Courage, which all of you have, and I recommend you reading it highly. So it's my distinct privilege to bring to the podium now the Honorable Richard Gergel.
Good morning, everyone, and congratulations on your selection to participate here in the James Otis Lecture. I remember as a high school student going to places we did not normally go and being excited to be exposed to something special and different, but most particularly to get off campus. You know, what a delightful thing, and getting out of class for the day. But you're not here just to provide you an interesting field trip. Let me give you a little secret what's going on here. Your teachers have identified you as the future leaders of your community. And it is critical that as future leaders, you understand and appreciate America's extraordinary experiment with democracy. This country has been a light to the nations. It has been an inspiration to the oppressed. But it does not happen by automatic hand from one generation to another, just by automatic inaction. It takes each generation to embrace democracy and to keep the flame lit by James Otis 260 years ago alive. That, my friends, is your job. And you are here to be prepared to assume your special place in America's democracy. In 1761, a prominent Boston attorney, James Otis, was retained by a group of businessmen to challenge the legality of a new colonial law known as the Writs of Assistance. This allowed British authorities to enter the homes of any person in the American colonies without advance notice, probable cause, or any announced reason whatsoever. Otis lost his case, but his inspirational defense lighted the spark that became the American Revolution. This eventually would lead to the formation of the United States of America. Otis is remembered as someone who, when confronted with injustice, had the courage to stand up for human dignity and the rule of law. He is often credited as the father of the Fourth Amendment of the United States Constitution, which established the constitutional right to be free from unreasonable searches and seizures, one of the most sacred rights of American citizens. Today, I want to share with you another more recent story of American citizens who, when confronted with injustice, had the courage to stand up for human dignity. This is the story of a returning World War II African-American soldier by the name of Isaac Woodard, who refused to accept the indignities of racial discrimination, and a judge and a president who stood up for the rule of law when this was a deeply unpopular thing to do. This is the story of unexampled courage. As the clock struck 7 p.m. on August 14, 1945, President Harry Truman, who had assumed the presidency just a short time before at the death of President Franklin Roosevelt, he summoned the White House press corps into his office to make a momentous announcement. Earlier that day, the Japanese government had unconditionally surrendered, bringing at long last World War II. The reporters spontaneously burst into applause and then headed for the door to make this momentous announcement, to share it with the rest of the country. Thousands soon gathered in Lafayette Square across from the White House. And soon there were calls, "We want Truman, we want Truman." The president came onto the north portico of the White House to make a few remarks. He said, "This is the day that fascism and police government ceases in the world. The great task ahead is to restore peace and bring free government to the world. But beneath the veneer of America's grand self-image as the bastion of freedom and liberty was a stark and tragic reality. African Americans residing in the old Confederacy lived in a twilight world between slavery and freedom. They no longer had masters, but they did not enjoy the rights of a free people. Black Southerners were routinely denied the right to vote. segregated physically from the dominant white society as a matter of law, and relegated to the margins of American prosperity. Racial violence and lynchings festered just beneath the surface, ready to explode at any moment. Can we, next slide, please? That image was known as the lynching flag. It flew outside the national office of the NAACP in New York the morning after every lynching in America. Between 1900 and 1950, it flew literally thousands of times. It was tragically a common sight in Manhattan. Most of these lynchings, but not all, occurred in the South. African Americans living in other regions of the country had their own challenges. But as the 900,000 African American soldiers returned stateside at the end of World War II, having put their lives and their futures on line for American freedom, they began demanding their own place in America's free government. They no longer would accept the discrimination. It was known as Jim Crow practices, racial segregation, disenfranchisement, meaning they didn't have the right to vote. They were no longer prepared to tolerate this treatment. Seen from today's perspective, the American triumph over racial segregation and disenfranchisement might seem to have been inevitable. The collapse of morally indefensible practices wholly inconsistent with the United States Constitution. But in 1945, with black Southerners almost entirely denied the right to vote, white-dominated Southern state governments resolutely committed to the racial status quo, and the federal government largely a passive bystander. There was no obvious path to resolving this great American dilemma. Something had to be done, but what and by whom? My book, Unexampled Courage, details the long overlooked story of the beating and blinding of Sergeant Isaac Woodard. Next slide, please. Sergeant Woodard was a battlefield-decorated African-American soldier from Fairfield County, South Carolina. He was beaten and blinded by the police chief of Batesburg, South Carolina, on the day of his discharge from the military, and while still in his dress uniform. And the book then traces the transformative impact of this horrible incident on President Harry Truman and United States District Judge J. Otis Waring of Charleston, South Carolina. Horrified and inspired by the injustice of this brutal event, President Truman would launch a civil rights program culminating in the ending of segregation in the armed forces of the United States. And Judge Waring would issue landmark civil rights decisions, including his historic dissent in 1951 in the case of Briggs versus Elliott, that would become the model for Brown versus Board of Education, the most important case in American history 3 years later. A little background. Late on the evening of February 12, 1946, Isaac Woodard boarded a Greyhound bus in Augusta, Georgia, with many fellow soldiers, heading the last leg home after coming from abroad. He was to travel on the bus from Augusta, Georgia, about 60 miles up the road to Columbia, South Carolina, the state capital, and then onward another 30 miles to his own rural community of Fairfield County, the town of Winsboro, where he was to rendezvous with his wife, who he had not seen for 3 years due to his military service. The bus stopped at every small town. And buses at that time did not have restrooms. And Greyhound bus drivers were instructed that when a passenger requested an opportunity to step off the bus to use the restroom, that was to be accommodated. At one of these stops, Sergeant Woodard stepped forward to the white bus driver and said, at the next stop, could I step off briefly? The bus driver was insulted for some reason by this modest request and told Sergeant Woodard, no, I ain't got time for this, and told him to return to his seat at the back of the bus. Sergeant Woodard stunned the bus driver when he responded, speak to me like I'm a man. I am a man just like you. The bus driver told the sergeant, go ahead, you can get off for this. And he did, got back on, no words were said. But that bus driver seethed as he went to the next town. And when he arrived in the next community, Batesburg, South Carolina, apparently no longer concerned with staying on schedule, he left his bus in search of a police officer to have Sergeant Woodard removed and arrested. A few moments later, the police chief, Linwood Shull, of this little two-piece person police force, summoned Sergeant Woodard off the bus. And when the sergeant tried to explain, I was just trying to use the restroom, the police chief took out his, what was known as a blackjack, which is like a baton but spring-loaded. They're illegal today. They can inflict tremendous injury, and hits the sergeant over the head, completely unprovoked. We know that happened because later FBI agents interviewed folks on the bus who observed this. Sergeant Woodard was placed under arrest, and he walked in, as the witnesses described, he left into the darkness of that evening. On his way to the town jail, which was just 2 blocks away, he was repeatedly beaten with that blackjack, finally falling to the ground. And when he became conscious, he literally passed out. The police chief took the end of the baton and stabbed it into each of his eyes. Next slide, please. That was at one point one of the most recognized images in African American newspapers across America. Isaac Woodard was permanently blinded by that attack. He woke up the next morning, he realized he could not see. And later that morning, he was taken to the town court, and he was convicted of drunk and disorderly conduct, though he wasn't drunk and he was not disorderly. Accounts of the Woodard beating and blinding were reported in African American newspapers across America and received nationwide attention when a renowned public figure, Orson Welles, a great movie producer and one of the greatest dramatic readers on radio, the primary medium at the time, had a national program on ABC Radio. And for 4 successive weeks, he told the story of the blinding of Isaac Woodard. Soon there were mass meetings organized in black communities across America. In one of those meetings in New York City, a benefit concert for the blinded sergeant had 23,000 people attend. Next slide, please. This is an announcement of that benefit concert. Major African American performers of the day, Count Basie, Cab Calloway, Nat King Cole, performed gratis to support the sergeant. And the chairman of the committee for this event was Joe Louis, then the reigning heavyweight champion of the world. Next slide, please. It's hard to describe today the role of Joe Louis. He was probably one of the most recognized and admired figures in America. In earlier years, he had knocked out Matt Schnelling to win the heavyweight championship at a time when tensions with Hitler in Germany were at the height, and here was a black man who had defeated, and he was an enormous figure. To have him sponsoring this program just tells you something. And Joe Louis was asked, he says, why are you trying to help this soldier? And he says, I'm always in my people's corner. On September 19, 1946, a group met with President Truman in the White House. Next slide, please. The truth was the incident involving Isaac Woodard wasn't the only incident involving the horrible treatment of returning black soldiers. They had, as I mentioned earlier, returned to America expecting something better. They had watched their buddies die in the battlefield. They had given up their youth to go fight for this country. And they returned to the same situation. 75% of African American soldiers came from the South, mostly from the rural South. So a delegation of civil rights leaders met with President Harry Truman in the White House, September 19, 1946, to ask the president's help in trying to do something about this wave of violence. But President Truman's staff told him, Mr. President, there really isn't much you can do as president. The federal government cannot effectively prosecute anyone because juries are all white in the South. Jury lists came from voter lists, and all white juries would not uphold the civil rights of black men and women. No legislation was possible because very conservative Southern committee chairs blocked any efforts at the advancement of civil rights. So once these leaders of the civil rights community urged the president for action to call Congress back into session to pass new civil rights legislation. And the president, who had always been sympathetic to civil rights, told him, he says, you know, the country is not interested in new civil rights legislation. In fact, polls showed 80% opposed civil rights legislation. But as this discussion was going on back and forth, there was a gentleman named Walter White. He, in this picture, is to our right of President Truman. Walter White is kind of a forgotten figure. He was the executive secretary of the NAACP at the time and was probably the most influential black man in America. He was also a friend of President Truman's and a big supporter. And as Mr. White listened to this discussion, he realized that Harry Truman did not appreciate the gravity of the situation. So he said, Mr. President, let me turn your attention to something I think you need to know. And he told him about the blinding of Isaac Woodard. Accounts of that session was that the place like froze in time. The president turned red-faced and his jaws clenched. He was furious. He had been a battalion commander in World War I. He revered soldiers. And the idea that a soldier, a United States soldier in uniform, would be treated in this way was something he just could not fathom. He turned to his staff and he says, my God, I had no idea it was as terrible as that. We have got to do something. And the next day he wrote his Attorney General and told the Attorney General the story of the blinding of Isaac Woodard. The president writes this letter. And he told him, it was a little bit of code to it, but it was clear that officer needs to be prosecuted. And furthermore, he said, we got to do more than just prosecute one case. We've got to address these very serious problems, racial problems that America obviously experiences. Well, 3 business days after this letter arrives in the Department of Justice, lawyers for the United States government filed criminal actions in the United States District Court in Columbia, South Carolina, charging the police chief with the deprivation of the civil rights of Sergeant Isaac Woodard. This was unprecedented at the time. The Department of Justice was not at that point bringing cases involving the prosecution of white police officers for the beating of black citizens. Meanwhile, the president appointed the first Presidential Commission on Civil Rights to try to address and come up with fresh new ideas for how to attack the scourge of racism, which was very much part of American society. Within 11 months, his committee was a remarkable group of people, prepared a comprehensive study called To Secure These Rights that listed dozens of proposals for changing institutional racism in America. One of their most important proposals was the desegregation of America's armed forces. The military was segregated by race. And though black soldiers had many opportunities in that segregated army for training and leadership and advancement, the forces were segregated. Many of his committee's proposals required action by Congress, which at that time was not going to happen. But remember, the President of the United States is the Commander-in-Chief. And on July 26, 1948, President Truman issued an executive order directing the immediate desegregation of the armed forces of the United States and of the Federal Employment Service. We can look back now and say that revolutionary, extraordinary, courageous action, when 80% of Americans were against it, but marked the beginning of the end of Jim Crow in America. It established the first fully desegregated, fully integrated institution in American life. By the time Harry Truman left office, 95% of military personnel were in integrated units. The Justice Department's efforts to prosecute Linwood Shull in the Federal District Court in Columbia, South Carolina, produced in the short term a very predictable result. An all-white, and my wife always points out, all-male jury acquitted the obviously culpable police officer after 28 minutes. Judge Waring had observed the trial. He had heard Sergeant Woodard's testimony. He knew it was true. And he was deeply distressed with the jury's verdict. His wife had attended the trial, and few noticed in the back of the room as she left, she was in tears. When they gathered together later that evening, the Warings discussed, the husband and wife, Elizabeth and Judge Otis Waring, discussed what they had just observed. The trial forced the Shull trial forced Judge Waring and his wife to stare directly into the Southern racial abyss, a view which would forever transform both of them. Judge Waring described that trial as his personal baptism of fire and his Michigan-born wife's baptism in racial prejudice. And next slide, please. Actually, I skipped over here. Here's the announcement of the President Truman desegregating the Army. President Truman wipes out segregation in the armed forces. Next slide, please. That's an image of Judge Waring. And the next slide, please, Genevieve. That is Judge Waring and his wife. The trial had been in Columbia. The Shull trial had been in Columbia. And the Warings returned to Charleston. And they realized they knew very little about these issues of civil rights, race, injustice. They had never paid a lot of attention to it. But they had just confronted this horrible act of injustice. But in white Charleston of that era, you couldn't talk about these subjects. It was not an open society. Judge Waring would later describe Charleston as like living behind the Iron Curtain. White people could not have an honest discussion about race. So what did the Warings do? Each night when Judge Waring came home, his wife would read a chapter from emerging studies of civil rights in American history. She would read it out loud 30 minutes to 45 minutes every night. And then they would ride around Charleston in the evening together, and they would talk about what they had just experienced. One commentator referred to the fact it was like they're running their own private seminar. And as they read these materials together, they finally reached a point that there was no turning back. Next slide, please. In 1947, as Judge Waring's views on race and justice emerged, a black businessman by the name of George Elmore filed suit in federal district court in Columbia, challenging the South Carolina Democratic Party's all-white primary. That is, only white people could vote in the one party's South. That meant if African Americans could ever figure out a way to overcome all the obstacles so they could register to vote, there was no one for whom to vote, because they couldn't vote in the only election that mattered. Mr. Elmore was represented by Thurgood Marshall, who at then age 39, chief counsel of the NAACP, was already developing a reputation of almost legendary proportions as a skilled litigator and legal strategist. Most other states, in response to a U.S. Supreme Court decision several years earlier, had agreed to allow African Americans, at least on paper, to vote in their Democratic primaries. But South Carolina took a different view. It abolished all the laws related to the Democratic primary, and then claimed their party was like a private club and they could control membership. Judge Waring spoke to Elizabeth, his wife, and said, you know, we've been talking about these issues privately, but if I rule for Mr. Elmore, our lives will never be the same. We will never be accepted in Charleston again. Our friends will not speak to us. I'm not sure what would happen to us. His wife, Elizabeth, said, I'm with you from start to finish. Judge Waring would later observe that his choice was either to be governed by the doctrine of white supremacy or to be a federal judge and decide the law. On July 12, 1947, Judge Waring issued his decision in Elmore versus Rice, declaring the white primary unconstitutional. Judge Waring ended his order by stating it is time for South Carolina to rejoin the Union and to adopt the American way of conducting elections. The groundbreaking nature of Judge Waring's decision, no Southern federal judge had ever issued a statement like this, an order like this. It was immediately appreciated at the highest reaches of the NAACP. With one close friend of Thurgood Marshall's writing, Thurgood, I have read the South Carolina opinion 3 times, and I still don't believe it. In many respects, I think it is your greatest legal achievement. But the opponents of integration would not give up. They adopted a new party rule in the face of Judge Waring's order that said African Americans can vote in our primary so long as they sign a loyalty oath pledging support for segregation. As Judge Waring would later say, no self-respecting black man would sign such a statement. Soon there was a new lawsuit, again in front of Judge Waring, challenging this new so-called loyalty oath. Judge Waring summoned the 93 members of the party's executive committee, the most powerful political leaders in South Carolina, to his courtroom in an emergency hearing. He told them, I will not tolerate you violating my order. He said a federal judge, faced with contempt of his order, can impose 2 sanctions: a fine or a jail sentence. He wanted those present to know there would be no fines if they violated his order again. He was telling them he was prepared to jail white political leaders to uphold the rights of black citizens. The response from the segregationists was thunderous. Judge Waring was denounced high and low across the state. Seemed like every elected official denounced him. Bricks were thrown through his living room window. A cross was burned in his yard. And there were so many threats to assassinate him that on the order of the Attorney General of the United States Marshals guarded him 24 hours a day. If the purpose of this unprecedented vilification of Judge Waring was intended to cower him, it simply did not work. Instead, he continued his study and reflection on race and justice in America and became convinced that the foundation of Jim Crow segregation, the Supreme Court 1896 decision in Plessy v. Ferguson, was legally, historically, and morally wrong. Judge Waring was convinced from his Elmore experience in the Elmore versus Rice case that if you drew a line and said, this is unlawful, the white community would obey it. And he also, when he finally threatened to jail these party leaders for violating his order, the resistance broke. And thereafter, thousands of African Americans were registered to vote. Next image, please. And that is an image of African Americans being sworn in as voters. And the gentleman, second one on the left there, is Mr. Elmore himself. Judge Waring wished to follow that model in attacking what he believed to be the foundation of segregation in America. Plessy versus Ferguson, the 1896 decision of the United States Supreme Court, the so-called separate but equal doctrine. The theory was it was constitutional to separate people by race, the government to do that, as long as it was equal. Well, let me give you a little secret. The practice was separate and unequal. And everybody in South Carolina knew it. It was no secret. Judge Waring had on his docket a case from Somerton, South Carolina, a little tiny impoverished community which was 80% African American, but all the wealth and all the power was in the white minority. The school board was all white. The citizens of Somerton black citizens of Somerton had a modest request. The white children have school buses. We want school buses. The Somerton School District, some children had to walk 9 miles to school. And of course, the result was that many simply did not attend school. Their request, this modest request, was turned down. And their leader, Reverend Delane, eventually turned to the great Thurgood Marshall to represent them. And he had brought this lawsuit in the United States District Court in front of Judge Waring to create equal facilities. To give the schools, the white children had fine modern buildings with indoor plumbing and landscape yards. And the African American schools were ramshackle buildings with outdoor privies and a well for water. This was a poster child of inequality. And the plan was to try to equalize those facilities using the Plessy case. But there was controversy within the NAACP and elsewhere that using Plessy versus Ferguson to win a case further cemented the inferior legal status of African American citizens. And in fact, the NAACP at the time was contemplating moving away from that practice. But the last place they would have tried it first was in Somerton, South Carolina, where the plaintiffs could genuinely fear for their lives if they were to make a frontal attack on segregation. Well, the trial was scheduled to begin on a Monday, and on a Friday before, we have what's called a pretrial conference. The lawyers come in and meet with the judge, try to address various legal issues in anticipation of the trial. Thurgood Marshall arrived that Friday in Charleston and came to the courthouse. He was told by the court security officer that Judge Waring wanted to see him in chambers. And when he arrived, he was summoned in to see Judge Waring. This is called an ex parte communication. One side there, the other side not. Generally not a favorite practice. It would be today considered very unethical. Judge Waring brought Thurgood Marshall in and he said, Thurgood, I don't want to try any more separate but equal cases. Bring me a frontal attack on segregation. Mr. Marshall said, Judge, it's on our agenda. It's just not tonight. Pretty cool response, don't you think? It's on our agenda, it's just not tonight. This is not the time, this is not the place. Meaning, they'll kill my clients if we do this. Judge Waring said, this is the time, this is the place. Because he knew, under certain circumstances, a 3-judge panel, 3 judges, not one, would be convened, and the appeal would go directly to the United States Supreme Court. And Judge Waring was convinced if the issue ever got in front of the Supreme Court, a majority would overturn Plessy v. Ferguson. And his goal was to get his case before the Supreme Court. Mr. Marshall left the office rather shaken that this judge was pushing him to do something which, as a cautious and very deliberate lawyer of incredible talent, he had been reluctant to do. Because if he had lost this case, he could throw all the progress they had made over the last 20 years onto the trash heap of history. He was very reluctant to get ahead of the Supreme Court. But here you had a judge that Mr. Marshall respected, even revered, telling him the time to challenge segregation and to attack it root and branch had now arrived. A few moments later, the parties convened in a courtroom just like this. And Judge Waring, he said, Mr. Marshall, are you challenging the constitutionality of segregation? He said, yes, sir, I am. He said, fine, I want you to dismiss this lawsuit and refile it, clearly stating the intent to challenge this case under the 14th Amendment. Shortly after this, Mr. Marshall brought his top assistant, Robert Carter, later a United States District Judge, sent him down to Somerton to explain to the plaintiffs this change in strategy. Mr. Carter said, Mr. Marshall believes we need to attack segregation now, but he recognizes that anyone who's in this lawsuit could face severe retaliation for doing so, and there will be no shame if you decide to withdraw. An elderly African-American gentleman at the back of the church where he was speaking stood up and said, we were wondering how long it would take you lawyers to figure this out. No one quit. Everyone stayed in. And that lawsuit was then scheduled in May 1951. Next slide, please. Thurgood Marshall arriving in Charleston for the trial of Briggs versus Elliott, the first frontal challenge to segregation in American history. This picture is iconic. It hung in Thurgood Marshall's Supreme Court offices after he went on to the U.S. Supreme Court, and it is probably one of the most published pictures anywhere of Thurgood Marshall. The picture was shot by a 14-year-old by the name of Cecil Williams, a young African-American photo bug who loved photography. He would go on to be one of the greatest photographers in modern American history. He lived in Orangeburg, South Carolina, and he heard the great Thurgood Marshall was coming to Charleston. And he got a family friend to drive him the 60 miles to Charleston. And in the old days, to take a picture with a flash, you had these little light bulbs. You had very few of them. Usually they were expensive. And when he got there, he realized he only had one flash bulb. And he got in front of the train, the door where Marshall was to come out, and with his one flash bulb, he took one of the most important photographs in American civil rights history. At the time when civil rights cases were tried, the courtrooms were generally empty. And why was that? Because African Americans were very reluctant to be identified as members of the NAACP. If you were, you could be fired for that, or to be identified as challengers to the racial status quo. So civil rights cases in that era were often to empty courtrooms, where the only persons present would be a few NAACP leaders who might be ministers or barbers or otherwise economically independent. But on the morning of the opening of the day of the trial of Briggs versus Elliott, African Americans from across South Carolina before sunrise got in their cars and drove and waited in line to come into the Charleston Federal Courthouse. Next picture, please. And they lined up, that's my courthouse, they lined up in front of the Charleston Federal Courthouse and down Broad Street as far as the eye could see. When Thurgood Marshall arrived that morning with Bob Carter, his assistant, he was amazed with his crowd. He was used to trying these cases in empty courtrooms. And as he's walking into the courtroom, he says to his young assistant, Bob Carter, "Bob, it's all over." And Carter said, "Well, what are you talking about, Thurgood?" He said, "They're not scared anymore. They're not scared anymore." That dramatic moment of this huge crowd appearing, Judge Waring, later in retirement, was interviewed, and he described the scene looking out of his office window as looking at a breath of freedom. Next picture, please. The great South Carolina artist, Jonathan Green, African-American artist, has painted this wonderful painting of the opening day of the trial of Briggs versus Elliott. You can see out of the window, Judge Waring is looking out of the window of his office with his African-American bailiff, and the great crowd below. And the title of that wonderful painting is Breath of Freedom. The trial, those in attendance, was mostly an African-American audience. They had come early, as I mentioned, and they had come far and wide because they believed they may be attending the most important case in American history. And they were not disappointed. They were amazed with the trial skills of Thurgood Marshall and his team. The trial included the testimony of Dr. Kenneth Clark. Next slide, please. Dr. Clark was a young psychologist. He and his wife, Dr. Mamie Clark, were the first African-American PhDs from Columbia University. And they had done studies attempting to understand the injury black children would experience from government-mandated segregation. And they showed black children black and white dolls. You can see here in this image, the child is looking at the black and white dolls in front of it. And they were asked questions. Which doll would you want to be your friend? Which doll do you think is dirty? Which doll do you think is nice? And the black children in communities across America would pick the white child for the positive traits and the black child for the negative traits. And the Clarks concluded that this showed the crippling effects of inferiority inflicted on black children by segregation. And there was a lot of controversy within the NAACP about whether to offer this testimony at trial. Today, testimony like this is offered frequently in American courtrooms. But in this period in 1951, it had never been done before. And Bob Carter, the young assistant, was a close friend of Dr. Clark's. He urged Thurgood Marshall to put up this testimony. So more experienced, older lawyers said it will look like a gimmick. Don't do it. But Thurgood Marshall finally said, after listening to the arguments on both sides, you know, I'm an old trial lawyer, and if I was trying to prove a client had a broken arm, I'd show an x-ray. He says, this is our x-ray on the injury of segregation to African American children. You know, it's kind of interesting, this huge debate over this testimony of Dr. Kenneth Clark. Judge Waring, in his dissent, quoted it extensively. And in the decision of Brown versus Board of Education, the Supreme Court said, we did not have in 1896 the evidence of Dr. Clark, of the injury of segregation to black children. Predictably, the two-person majority on the panel of three upheld the lawfulness of segregation in South Carolina schools. But Judge Waring, knowing he was writing a dissent for the ages, wrote a brilliant attack on segregation in America. He concluded by finding that segregation in education can never produce equality, and it is an evil that must be eradicated. Segregation in education adopted and practiced in the state of South Carolina must go and go now. Segregation is per se inequality. Written in June 1951, 3 years before Brown versus Board of Education. Judge Waring in his dissent also praised the Briggs plaintiffs. Next slide, please. 21 courageous souls who had faced, and he knew, severe retaliation for being plaintiffs in this action. The lead plaintiff, Mr. Briggs, had been a gas station attendant. He had been brought in on Christmas Eve and told his job of many years was over. His wife, worked at a local motel, cleaning rooms. She was brought in and fired. Reverend Delane, the leader of the group, was fired as a principal of the school. His wife was fired. His sister was fired. His niece was fired. Loans were called. They could not get credit. Their cotton would not be factored. Most ended up having to leave the county because they could not make a living. Judge Waring in his dissent stated that the plaintiffs have shown unexampled courage in bringing and presenting this cause in the face of the long-established and age-old way of life which the state of South Carolina has adopted and practiced and lived in since and as a result of the institution of human slavery. Judge Waring's dissent was the first challenge by a federal judge to government-mandated segregation since the great dissent in Plessy by one judge, Judge Harlan, 55 years earlier. I want to give you if we go to the next slide, please. This is just an example of what was going on at the time. This is a gentleman who was admitted to the graduate program at University of Oklahoma in the Graduate School of Education, but he was required to sit outside the classroom and not allowed to sit with his fellow students. This is what we were facing pre-Brown versus Board of Education. In early 1952, some 6 months after the Great Dissent, Judge Waring wrote President Truman and advised him he was retiring as United States District Judge. Exhausted by the treatment in Charleston, ostracized, his friends would not speak to him, he and his wife moved to New York City. And there he later filed cases from Virginia, Delaware, and Kansas, all which were eventually consolidated before the United States Supreme Court under the name, with Briggs versus Elliott, Brown versus Board of Education. And all the other school desegregation cases, 14 different state and federal judges involved, only Judge Waring concluded that even if the facilities were equal, racial segregation violated the American Constitution. On May 17, 1954, the Supreme Court handed down unanimously its landmark decision in Brown versus Board of Education. Next slide, please. It's hard to see here unless you're closer up, but the second case there, first case is Brown versus Topeka, Kansas. Second case, Briggs versus Elliott. The court unanimously cast aside the separate but equal doctrine and adopted the per se rule that all government-mandated public school segregation was unconstitutional, first advanced by Judge Waring in his Briggs dissent. Judge Waring was always philosophical about what he called the unpleasant repercussions of his civil rights decisions, which had completely transformed his life and which eventually sent him in exile out of South Carolina. He described himself in retirement as enormously fortunate to having had the honor to uphold the American Constitution. Next slide, please. Shortly before I completed my book, I visited the town of Batesburg and retraced the fateful path that Isaac Woodard had traveled that day. From the bus stop where he was pulled off the bus, around the corner where he was beaten and blinded, and up the street to the jail where he was thrown the next day and then prosecuted in the city courts of Batesburg. With me on that visit, I was trying to make sure I understood exactly the physical presence of certain landmarks, some which had changed in the 70 years since. And I had the town attorney there helping me. And he brought along someone with him, the mayor of Batesburg, whose last name was Shaw, the same last name of the police officer who had beaten and blinded Isaac Woodard. Let me just say, I paused for a moment. What had I gotten myself into? And we walked the path, and it was clear to me that both the city attorney and the mayor were learning much of this story for the first time. People tell me all the time, I never heard this story. Well, the people in Batesburg had never heard this story. And as we finished this incredibly moving walk, the mayor grabbed me by the elbow and pulled me aside. And he said, my town's got to do something in response to this. We've got to make it right the best we can. And I looked at him and he said, oh, by the way, I'm from Missouri. I'm not related to the Shaws here. That was a relief, okay? And the town thereafter, the town attorney went into court and moved to reopen the case of the town of Batesburg versus Isaac Woodard, the unjust conviction, and asked the court to overturn it, which it did. And then in 2019, next slide please, the town, at its expense, erected a historic marker candidly telling the truth of the blinding of Isaac Woodard. Standing there was Robert Young, Sergeant Woodard's nephew, who had been his caregiver through his many years of living with blindness. This is a tragic story, folks, but it is also a story of redemption of the American system of justice. I just started the discussion about the James Otis contributions to the American Revolution. And it shares in common the story of unexampled courage, of how individuals standing up for what is right and just and committed to the cause of justice can promote a fairer and more just society. In a few short years, ladies and gentlemen, it will be your turn to show unexampled courage. You will begin to vote and participate in community affairs. You will be the leaders of our communities in the future. a torch will be handed to you to continue this great American experiment. When you receive that torch, it will be your sacred duty to maintain that fire James Otis lighted 260 years ago. Thank you very much.
Thank you, Judge Gergel, for an absolutely spellbinding presentation. Ladies and gentlemen, I strongly encourage each and every one of you to get a copy of Judge Gergel's book. I don't get any referral fee, by the way, but it's just a fascinating story of a tragic situation and a truly heroic judge. I think all of us judges here can only hope to demonstrate the courage that Judge Waring demonstrated in the decisions that he rendered. And with that, I believe we are going to adjourn for a few moments and then reconvene in the atrium. Is that right, Michael? And we'll have some further discussion at that time. I know you're all hoping not to have to go back to school today, and if there's any way I could stretch this out for you, I would, but I don't think I have that power. So we'll see you in a few